something's upsetting you, just come on out. Do you want me to get you out now?
Good, how about you?
No, it's fine, I'm right. I can do it.
All right, are we ready to bring in the jury?
Thank you, Sean.
All right, Susan? Jury? All right, Mr. Lawrence, will counsel for defendant Wayne Greenlaw be putting on a case at this time?
Will, Your Honor.
All right, who will be your first witness be?
Stephen Howard. May we ask if you're going to be
Yes.
And Judge, this is a joint defense witness.
All right, and that's a good point. At an earlier stage of the proceeding, we had joint witnesses with me, and all of the parties, the state as well as each of these defendants, were utilizing a witness. Now, at this point, the state has rested. They will not be part of any joint witnesses, but there are some witnesses that the defendants are calling together jointly. So that's the reason this is called a joint defense witness.
Okay, follow me, sir. You're going to head up to the podium. There, you're going to raise your right hand to be sworn in and answer out loud. Sir, podium. Raise your right hand.
You solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Okay, follow me, sir. This is the way. Witness is seated.
You may inquire.
Thank you, Your Honor. Good morning, Mr. Howard. Would you state your full name for the record, please, and spell your last name?
Stephen Charles Howard, Howard.
And Mr. Howard, how are you employed?
I'm a firearms ballistics expert and practicing attorney.
What is your educational background concerning firearms?
I am a third-generation gunsmith. I have an associate arts and science degree in gunsmithing. I have a Bachelor of Science degree in criminal justice. And I've had education and training through the Federal Law Enforcement Training Academy as well as through the Department of Defense Federal Police.
What other degrees do you hold?
I also have a Juris Doctorate in law from Thomas Cooley Law School.
Have you ever been published in the area of firearms or firearms-related subjects?
Yes, I've been published 11 times.
And were those articles peer-reviewed?
Yes, they were.
Have you ever taught firearms-related subjects?
Yes, I have. I've taught firearms and the law through the Lorman Corporation as a continuing education company that teaches police officers, judges, attorneys. I've also taught ballistics and ammunition manufacture through the University of Southern Colorado as an adjunct professor. And I've taught a number of other things.
Have you ever been recognized as a firearms expert in various courts in the United States?
Yes.
How many times have you been recognized, or strike that, how many states have you been recognized as a firearms expert?
14.
Have you ever been recognized any in the state of Florida?
Yes, twice, not counting this one.
How many times have you testified as a firearms expert in various states of the United States?
30 plus.
At some point in time during the course of this case, you were asked to examine the various firearms related to this case, were you not?
I was.
And where did you conduct your examination of those firearms?
At the county evidence storage facility.
And what firearms did you examine?
I examined a Ruger brand Mini 14 in .223 Remington caliber. I examined a Sig Sauer model 226 9mm pistol, semi-automatic pistol. And I examined a Winchester brand model 1200 pump slide action shotgun in 12 gauge.
What were your results, or strike that, what were the results of your examination in reference to the Ruger Mini 14?
The weapon was in sound mechanical condition. Everything about it fell within manufacturer's parameters. And other than the fact it needed cleaning because it had not been cleaned from the last time it had been fired, whether that be by the police testing it or on the night in question, I have no way of knowing. But other than the fact it needed a cleaning, it was in good mechanical condition.
Did you examine the trigger pull of that?
Yes,
And what were the results of that?
they were within manufacturer's parameter.
And in reference to the 6 hour, what sort of an examination did you do?
I examined it again for mechanical suitability. I did a limited disassembly to check for excessive dirt or wear. I found none. The trigger pulls were both double action and single action were both within manufacturer's parameters.
And did you also do an examination of the Winchester Model 1200 pump shotgun?
I did.
And what kind of an examination did you do in reference to the shotgun?
The pump shotgun was examined for suitability. Again, the trigger pull was tested, the safety was tested, both were working within manufacturer's parameters. I also test fired the weapon by using a shotgun shell that I had stripped out the pellets or projectiles, if you prefer the term. I removed the wad and the gunpowder, leaving only the primer. I took the shotgun and put it muzzle first on top of a phone book to dampen the sound. The shotgun primers are quite loud. And fired just the primer by pulling the trigger. The weapon discharged without incident. I then attempted to determine the magazine capacity of the shotgun. I took 2 gummy shells, placed them in the magazine, then attempted to place a third one. The third one would not enter the magazine. This indicates that the shotgun was plugged, term of art, meaning that there was a device that kept more than 2 shells from being placed in the magazine at any one time. Then I removed the barrel restraining nut, which is located at the end of the magazine tube. And upon removing this cap, and it's a cap about 1.5 inches round, I could see the Winchester brand wooden plug, which comes installed in all Winchester shotguns, clearly in place and working perfectly.
As a result of that examination, were you able to determine the number of shells that that shotgun in fact would hold?
It would hold a total of 3, 2 in the magazine plus 1 in the chamber for a total of 3.
Were you asked to conduct any other tests related to the types of firearms that are in question in this case?
I was.
And where did you conduct those tests?
At my testing facility outside Potterville, Michigan.
What kind of tests were you asked to conduct?
The test was to determine how fast or how quickly 13 rounds could be discharged from the 6-hour 9mm pistol and from the Ruger Mini 14 rifle. The shotgun was tested to see how quickly 2 shots could be fired using double buckshot loads.
And in reference to that test, were you asked to document that by video recording?
I was.
And did you in fact have someone do that?
I did.
Which firearm model did you test first?
The Sig Sauer 9mm pistol.
And what were the mechanics of actually performing the test?
I loaded 13 cartridges into the magazine, locked the pistol slide in the rearward position, inserted the magazine, dropped the slide, then hit the decocking lever. This is a lever that allows the hammer to come down without discharging the weapon. I then turned on a timer that has a delay. Once the timer goes beep, that's the signal to go. I then discharged the rounds as quickly as I could, and the timer would record the time of from the beep to the last shot.
The magazine that you used, you indicated that you put 13 shells into the magazine. What was the capacity of the magazine?
15 rounds is standard for the model. Extended magazines, however, are available.
And you indicated that you used a timer. Can you tell me the brand, make, and model of the timer?
The brand is CED, model 7000 range timer. It's pretty much the standard of the speed shooting industry.
And what is speed shooting?
Speed shooting is going through a course of fire to see who can hit a set number of targets the fastest.
And is this the timer that is used, the standard timer that is used in that particular industry?
Yes, and to include all the championships.
All right. And were you, in fact, capable of performing the test on the 6 hour?
I was.
And did you repeat that same test in reference to the Mini 14?
Each weapon was run through 2 tests each.
When it came to the shotgun, did you also perform 3 tests? How many strike that? 2 tests?
Yes, I did.
And what did you do in terms of firing a shotgun?
I loaded it with 2 cartridges, and upon the start beep by the timer, I discharged 2 shots at at 2 basically separate targets as quickly as possible.
Now, do the weather conditions, well, strike that, where are you from?
Michigan.
All right, and you conducted the test in Michigan, is that correct?
That is correct, sir.
And do the weather conditions in Michigan, as opposed to the weather conditions that were in Florida at the time of this event, would they have any impact upon your test?
No, my feet were cold.
Other than your feet being cold, what other impact, if any, would there be?
None.
Have you had an opportunity to review the video tape recording of the test that you performed?
I have.
And does that video tape that you reviewed fairly and accurately reflect the test that you in fact performed?
Yes.
The video that you sent to defense counsel, which was shared with the state and with the court, has been edited by a series of orders from the court. Have you reviewed the edited version?
I have.
And other than the parts that were edited from it, does it fairly and accurately reflect the test results that you did?
Yes, it does.
Your Honor, I would ask at this time that we be allowed to play the video.
Any objections?
I'll remove my objection and expect the same outcome.
Based upon prior court rulings, I will overrule that objection and you may play the tape.
Very good, thank you.
Take the screen down and bring the lights down.
Okay, 13 shots, 9mm, SIG 220, or 226, excuse me. And this is an electronic timer. Times from the time it goes beep to start until the last shot's fired. The experiment here is how fast 13 shots can be fired. Chambering the first round, and now setting down the hammer, starting from the double action position. And ready. Three 0.61 seconds. I'm going to repeat the experiment. First clip of 13. Decocking. Clear. And start. .82. Okay, this is the Mini 14. Same calendar, year basically, same configuration. The only difference is this one has a scope. This is a flash hider, not a muzzle brake. It does not affect general shooting characteristics. I have 13 rounds of 223, and we're going to see how long it takes to fire 13 rounds. So, ready, and start. .78 seconds. Okay, same experiment. 20 rounds, Mini 14. We'll see how long it takes. .3 seconds. We're going to shoot the shotgun and see how fast it takes to fire two rounds double aught buck. .18 seconds. .99 of a second.
Mr. Howard, you've had an opportunity to review the video of the experiment that you were asked to perform. Does that video, in fact, fairly and accurately represent the test results that you gleaned from the firing of the weapons?
It does.
All right, now, there was one thing that I did note in there, and I want to say it was the second firing, perhaps, of the Mini 14. You indicated that there were 20 rounds in the magazine. Was that just an error on your part?
It's a 20-round magazine,
Okay.
but it only had 13 shells in it.
I thought it might have indicated otherwise. Your Honor, I believe that's all the questions that I have. Thank you. At this time, I would ask that what has previously been marked as defendants 4H, H, 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 be introduced into evidence.
And counsel for defendant Ray Greenlaw is in agreement with that.
That's correct, Your Honor.
And any objection, Mr. Well?
Just the same objection from the state.
I will overrule that objection based on the court's prior rulings and enter defendants exhibit H, 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 H for identification as defendants exhibit number 28.
Your Honor, I have no further questions. Thank you.
Counsel for Ray Greenlaw wish to inquire?
Just one question. Sir, when you testified that you came down and inspected the shotgun in this case?
Yes.
Okay, you remember, that's been since the beginning of the year.
If memory serves, it was January the 16th of this year.
Okay.
Mr. Well, cross-examination.
Yes, ma'am. Good morning, Mr. Howard.
Good morning, sir.
How are you today?
Very good.
Good. Now, you weren't present the night that Brian Leverett was killed,
That is correct. I was not.
and there's no evidence to suggest how quickly the shots were fired.
None.
You only, in this video, you only fired the 9mm and the Mini 14 range rifle as quickly as you could. Is that correct?
Ranch rifle, it's
The-
not a ranch rifle.
Excuse me, the Mini 14.
Can you repeat the question, please?
You fired, in the video, you fired the 9mm and the rifle as quickly as you could, correct?
Yes.
But the weapons could have been discharged much more slowly and methodically on October 29th of 2011.
Yes.
Now, you're not a crime scene investigator for the Volusia County Sheriff's Office,
No.
and you're not a laboratory analyst for the Florida Department of Law Enforcement.
Sir, I'm having a hard time hearing you.
You're not a crime scene investigator for Volusia County Sheriff's Office?
No, I'm not.
Okay, and you're not a laboratory analyst for Florida Department of Law Enforcement?
No,
In fact, you're not even from the state of Florida, you're from Michigan.
that is correct.
And you were brought here to testify this morning for the defendants,
Yes.
and you're being paid to do that.
Yes.
And when you're not being flown around the country to testify, you're a practicing attorney.
That is correct.
And a substantial part of your practice is dedicated to the representation of criminal defendants, just like the Greenlaws.
Yes.
Thank you.
Read it back, Mr. Lawrence.
Amen.
Mr. Ballerina. And then read the release Mr. Howard from his subpoena.
From my perspective, yes.
No objection to that, Your Honor.
Okay.
All right, sir, you are releasing your subpoena. You can go. What is that?
Thank you.
Mr. Lawrence?
Your Honor, that's the only witness that I intend to call, but we have joint witnesses from Mr. Ballerina's perspective, so at this point in time, I would rest.
All right, the jury will be escorted into the jury room for a brief moment. At this point, there is a legal matter that needs to be addressed. It won't take us long. Claire, everyone may be seated. Motion on behalf of defendant Wayne Greenlaw.
Yes, Your Honor. Michael Nappy on behalf of Wayne Greenlaw. At this time, Mr. Greenlaw will renew his previously made motion for judgment of acquittal under Florida Rule of Criminal Procedure 3.380 on the same grounds as previously stated at the close of the state's case. We would also add that the state has failed to prove a prima facie case as to count 3 of shooting into a building, whether the act was done wantonly or maliciously. Wantonly is defined as consciously and intentionally, with reckless indifference to consequences, and with knowledge that damage is likely to be done to some person. Maliciously is defined as wrongfully, intentionally, and without legal justification or excuse, and with the knowledge that injury or damage will or may be caused to another person or property of another person. There is no evidence has been indicated whether or not Mr. Wayne Greenlaw acted wantonly or maliciously. Both of those definitions include the element of intentionally. We know that under the legal definition, intentionally is knowingly and purposely. We say that the state has failed to prove a prima facie case as to those two definitions, which therefore would say that they failed to prove a prima facie case as to count 3 of shooting into a group. Thank you.
Mr. Nash, Mr. Will?
State removes its previous argument.
With the exception of the argument addressing the additional count, the court's ruling would be the same as before. Again, there is evidence on both sides. None of that evidence is strongly or specifically rebutted. It's up to the jury to make the factual determination, not this court, and therefore the motion for judgment of acquittal will be denied. Anything further on behalf of the defendant, Wayne Greenlaw? Oh, I do need to ask him. You rested.
Oh, yeah. May I just
Yes.
briefly before you?
Yeah.
Your Honor.
Right. Have a microphone.
I can plug it in.
Plug it in and make sure the record. It'll actually work better if you remain seated.
Okay.
Thank you, Governor.
And it's gonna make noise.
Mr. Greenlaw, excuse me, for clarity of the record, Mr. Wayne Greenlaw, at this time, the court needs to inquire as to whether or not you wish to testify in this matter. Have you had an opportunity to discuss that decision with your counsel?
Yes, I have.
And do you wish to testify in this matter?
No, I don't, ma'am.
I need to ask you a few questions regarding that decision. First of all, have you had any alcohol or drugs that you do not have a prescription for any time in the last 24 hours?
No, I haven't.
Have you ever been diagnosed with a mental illness or a mental disability?
No, I haven't.
Do you feel in any way that you have been forced, coerced, pressured, or threatened not to testify?
No.
And you have had a full opportunity to ask your attorneys the pros and cons of testifying?
Yes, I have.
And this is your decision?
Yes, it is.
And you want to maintain your right to remain silent at this point?
Yes, I do.
Thank you. Right. Can I unplug the microphone?
I am, but I'm gonna leave it for the future.
And just for defendant Wayne Greenlaw's understanding, at that table, the microphone is there, but it's not plugged in, so it's not working yet. It's being used when the time is appropriate.
I just got Mr. Greenlaw to ask this in the question he asked Mr. Brother.
Are you ready to proceed, Mr. Valero?
Yes.
All right. You're ready to be brought back in?
Jury.
before defendant Ray Greenlaw's counsel will present the evidence or testimony to you, I want to take you back to last Friday, if you can recall. On that day, the state, as well as Mr. Lawrence, on behalf of defendant Wayne Greenlaw, made an opening statement. However, counsel for Ray Greenlaw deferred their opening statement. So at this time, you will be hearing an opening statement from counsel for Ray Greenlaw before they present evidence. Mr. Valerino, if you're ready.
Yes, sir. Thank you. Members of the jury, probably haven't heard me speak a whole lot during this trial. Procedurally, we went last, and actually by the time we got to us asking questions, it seemed like pretty much all the questions that needed to be asked were asked and answered. This is the opportunity that I have to make a brief opening statement, and on the conclusion of my opening statement, we're going to call a few witnesses to testify on behalf of both Ray Greenlaw and Wayne Greenlaw, because the three witnesses that will be called to testify will be joint defense witnesses. But you've all had the opportunity to hear the testimony of the witnesses that testified during this trial. You've all had the opportunity to look at the physical evidence. And when I talk about witnesses, I talk about both joint witnesses and state witnesses. But what I want to do is, in my opening statement, just briefly talk about the testimony that has been presented to date, and then tell you a little bit about what I expect the further testimony that you will hear will be. You heard from Eric Robinson, first witness in the case, and he talked about living at 8 Aspen Street, that he left for work about 5:15, 5:20 in the morning on October 29th, 2011. He saw 4 or 5 men standing on a porch or on a patio area at 9 Aspen Street, and didn't see anybody arguing, and proceeded on to work in Sanford. You heard from Nicole Robinson, his wife, who also lives at 8 Aspen Street. And you heard her testimony regarding hearing some shouting. She saw a fight. There were 4 men out in the yard at 9 Aspen Street. And she called 911. And the evidence indicated that she called 911 about 5:36 and 36 seconds on the morning of October 29, 2011. And you had the opportunity to listen to her 911 tape. It was about 20-some minutes long. And Ms. Robinson basically testified here that she was relaying on the 911 tape what she was seeing as she was seeing the events that were occurring. She talked about seeing a fight and hearing fired gunshots, talked about seeing a flashlight, or what she thought was a flashlight, walking from the west on Aspirin up towards 8 Aspen Street where she lived, and 9 Aspen Street where the Greenlaw brothers lived. I think the last witness that we heard on Friday was Diane Housley, the lady that lived across the street at 10 Aspen Street, lived across the street from the Greenlaw residence. And you heard her testify that she was asleep. She heard some loud voices. She heard a person who she believed to be Ray Greenlaw telling 2 people that they needed to get off his effing property. Said that at least 3 or 4 times. She thinks that occurred about 5:35 in the morning, which is around the same time, within a minute or two, of when Nicole Robinson made her 911 call. She testified, she heard someone say, "I've got a 45," and another person saying, "I did have they also had a 45. She heard some gunshots. She testified that it sounded like these two people were mocking Mr. Ray Greenlaw. It sounded like they were giving him a hard time. It sounded like, or it looked like they tried to charge him a couple times, and also that they were not moving when they were being ordered off the property. You've had the opportunity to hear the testimony of Mary Ann Fitzgerald, and she was the first witness who testified here this week on Monday. She indicated she was staying at 13 Azalea. She got up about 5:30 in the morning to have a smoke. Saw a person who she knew is Brian Leverett, who, according to the testimony, kind of lived catty corner from where she was staying, and saw him come up, go into the house, come out with a long object and a flashlight, and you heard her testify that the flashlight was on when she saw him heading up the street towards the direction of 13 Aspen. She indicated that she had talked to Brian Leverett on numerous occasions, and based on her prior conversations with him and listening to him that night, it sounded like he was intoxicated. And then she testified that after she saw Mr. Leverett walking towards 13 Aspen Street, that she heard a lot of gunshots. The next witness, to refresh your memory, was a Daniel Meadow. And Mr. Meadow indicated he was staying at 13 Aspen, that he heard a bang, thought he might have heard a gunshot or two, and saw Justin Riley bleeding, and ultimately Mr. Riley was brought into the house at 13 Aspen, and during this series of events, he heard a chain link fence. He called out, and he determined that the person that was at the chain link fence was Brian Leverett. He testified that he heard Mr. Leverett make some comment about the neighbors were trying to kill Justin. He indicated that he saw Brian Leverett with a flashlight. The flashlight was on, and that Brian Leverett had a shotgun. He testified that it appeared that Brian Leverett was upset, that Brian Leverett made a comment to the effect of, "I will shoot that motherfucker." And although Mr. Meadow kind of went back and forth in his testimony, he indicated that he was certain that that's what Mr. Leverett had said. Mr. Meadow also indicated from the testimony that when Mr. Leverett was out there at 13 Aspen, he had the shotgun up with the flashlight. He was sweeping the area, and that they saw someone, that Mr. Leverett fixated the shotgun and the flashlight on that person that was standing in front of him, and that Mr. Leverett ordered that second person to put the effing gun down. There was an exchange of words, and Mr. Meadow indicated that he didn't know who fired first, but he saw Mr. Leverett shoot the shotgun. He also heard the testimony of Kurt Madison. He was the fellow that was at the Halloween party. There, I think the address was 17 Aspen. And the times are very consistent with everybody. He thought it was about 5:30 when he heard some arguing. He thought he heard a couple gunshots. He looked over a fence, eventually went out into the front yard there at the I think it was 17 Aspen that he was staying at or going to the party at. And he saw a person who we later know to have been Brian Leverett run past him. And that he heard Mr. Leverett say something about they tried to chop my friend in half. Mr. Madison indicated that he saw this person, Brian Leverett. He didn't know the person, but we all know that it was, Mr. Leverett, go into the house, come out with a shotgun or rifle. Mr. Madison indicated he didn't notice a flashlight, but he was positive that Mr. Leverett came out with either a shotgun or a rifle. Mr. Madison indicated he never lost sight of Mr. Leverett, and that he saw Mr. Leverett point the shotgun in an area between two houses. He didn't know the addresses of the two houses, but he saw Mr. Leverett point the shotgun between the two houses. He indicated that from his recollection, Mr. Leverett pointed first, and that he saw a second person between the two houses. And at that point in time, the two people, Leverett and that second person, were pointing guns at each other. And then he heard some shots. The next witness that you've heard was Justin Riley. You had the opportunity to, he's the one who is alleged to be the victim of the attempted murder, the alleged victim of the machete incident. You had the opportunity to listen to his testimony. You had the opportunity to observe his demeanor as he testified there on the stand. And his testimony will more appropriately be addressed during our closing argument that we'll be making on Monday. You then heard Barbara Medow. She was at 13 Aspen. She pretty much related what happened inside 13 Aspen, seeing Justin Riley bleeding, hearing shots, ultimately Mr. Riley being taken to the hospital. You heard the testimony of Scott Searles. He was the person who came in the jail garb, belly shackled, and the chains on his ankles. He testified that he was in jail because he refused to come to court, so they had to issue a warrant for his arrest to try to make sure he showed up for court. He also testified he had a couple of cases pending against him here in Volusia County that had not been resolved. And again, just like Mr. Riley, you had the opportunity to hear his testimony. You had the opportunity to observe his demeanor on the stand. His testimony and his demeanor on the stand pretty much speaks for itself. But again, that's an issue that it's not appropriate to get into here in an opening statement, but will be discussed when we get to the closing argument again that we're going to have on Monday. You heard the testimony of Kendra Walls. Basically, her testimony contradicted many of the things that Scott Searles said. For instance, she said that she didn't go to the Greenlaw residence with Scott Searles, when Scott Searles said that she did. She talked about being out at this dry lake area where she had met Riley and Mr. Leverett, and there had been a call received from Wayne Greenlaw complaining about Justin Riley and Mr. Leverett marching into the house. She testified that Scott Searles invited them to go over to the house, that Riley and Leverett were told, don't go over there until we're there, which again was in conflict with the testimony of Scott Searles. You heard her testify that she admitted to lying in regard to an issue regarding what she had been told by Scott Searles after she had left, and that she had done that to protect Scott Searles. Next person that you heard testify was a Deputy Keaton. And basically, he talked for a little while, but the meat of his testimony was that the call in this incident was created at 5:36:36. In other words, 5 o'clock in the morning, 5:36 and 36 seconds, which we know from the evidence would have been the call that Nicole Robinson made. And that units arrived, according to his testimony, about 11 minutes later, 10 or 11 minutes later at 5:47:02. You heard the testimony of Investigator DeWeese. He was the crime scene investigator. He testified that when he examined the shotgun that was found in the carport at 13 Aspen, that the safety was off. There was some